Well, good morning, everybody. We'll carry on looking at the decision by William Griesbach, Mike Griesbach's brother, in the case of Stephanie Van Grohl's civil suit against Ken Kratz. And one of the things that struck me is that how thorough William Griesbach is in covering the sexting career in the case of certainly Stephanie Van Grohl. And contrast that with the total embarrassment that is Judge Angela Sutkovich on something, to me, that seems far more important. You know, the issue of somebody being wrongfully imprisoned can hardly write more than 10 pages on something as important as bones being handed back when they shouldn't have been, and all her other decisions that have been absolutely pathetic have not addressed anything. And as I say, although obviously the getting rid of Ken Kratz very, very important, and this civil suit important, to me that's not as important as somebody being wrongfully convicted. I can only hope that the judges in Wisconsin regard Sutkovich as a total embarrassment to the whole sort of what should we call them, the collective for judges. Anyway, whatever that is, she must surely be regarded as one of the worst. We know for a fact that she is the one that is most asked to be replaced with somebody else. Anyway, let's carry on, as I say, crack on with the next paragraph of this decision by William Griesbach. And he now looks at, the next paragraph is headed Analysis. And he wrote that liability requires proof that the defendant was acting under colour of state law and that his conduct violated the plaintiff's rights, privileges or immunities secured by the Constitution or laws of the United States. Kratz does not contest Stephanie's allegation that he acted under colour of state law with respect to the conduct at issue. Instead, Kratz contends that the evidence, even when viewed in a light most favourable to the plaintiff, does not provide a basis upon which a jury could find that he violated Stephanie's rights to equal protection under the 14th Amendment. Alternatively, he claims he is entitled to absolute or good faith immunity by virtue of his office. Stephanie counters that intentional sexual harassment by government actors violates the constitutional right to equal protection under the 14th Amendment, and that the evidence in this case, viewed in a light most favourable to her, is sufficient to allow a reasonable jury to find in her favour. She also argues that given the state of the law with respect to sexual harassment, Kratz is not immune from liability for the damages he caused. Item number 1, equal protection violation. There is no doubt that sexual harassment is actionable in the employment context under Title 7, Roman number 7, VII, of the Civil Rights Act of 1964. The Seventh Circuit has long held that sexual harassment by government officials can also violate the Equal Protection Clause of the 14th Amendment. This violation is most apparent in the employment context. Creating abusive conditions for female employees and not for male employers is discrimination. But sexual harassment may also violate the Equal Protection Clause outside the employment context. For example, the Seventh Circuit held the Equal Protection Clause prohibited school officials from denying students, on the basis of sex, protection from sexual harassment. The Equal Protection Clause has also been held to bar sexual abuse and harassment of students by teachers and school personnel. Furthermore, while defendant suggests an individualised case cannot proceed, case law indicates plaintiffs need to show harassment of other females by the same defendant to prove intentional sexual harassment under the Equal Protection Clause. Certainly, harassment of other female employees by the same defendant may be strong evidence supporting the claim, but a single harassing act can still be enough to establish discrimination. Moreover, in this case, Stephanie alleges that Kratz made similar unwelcome sexual advances over a period of months towards other domestic abuse victims, in a case he was prosecuting on a previous occasion. She also argues that in order to state an equal protection claim for sexual harassment outside of the employment context, the defendant must have authority over the plaintiff and threaten to use such authority to coerce the plaintiff into submitting to sexual relations. Defendant, obviously, Kratz. Kratz contends that proof of an actual threat of denial or some tangible benefits in order to coerce compliance is required. Because he had no authority over her and never even suggested that how he handled the prosecution of Shannon Konitzer depended on her response to his solicitation, Kratz argues that Stephanie's claim must fail. However, but while Kratz may not have had the same kind of authority an employer or teacher has over an employee or student, he did have authority over the prosecution of a man whom he knew posed a serious threat to her safety. This is quite good. Arguably, William writes, this gave Kratz far more power over her than either a supervisor at work or a teacher at school. For example, one's supervisor at work can cause economic harm to an employee under his supervision, and a teacher at school can damage a student's academic record. As far as Stephanie was concerned, Kratz had the power to unleash a serious threat to her physical safety. Moreover, while it may be difficult to change jobs or transfer to a different school, these are steps that employees and students can take to avoid the risk that a supervisor or teacher can pose. The risk to her physical safety that Ken feared could not be so avoided. So basically what he's saying is that, being the prosecutor of her ex-boyfriend, that the possibility that he could reduce the charges to just a misdemeanor was going to be seriously threatening to Stephanie. And although those words and those phrases weren't actually used, this was what was being implied by Ken Kratz. It says, just this now, it says that it is true that Kratz never threatened or even suggested that his handling of Shannon Konitzer's prosecution was in any way dependent on plaintiff's response to his overtures. But as Stephanie's response highlights, such coercive threats or quid pro quo offers are not required in order to establish an equal protection violation. He quotes various cases that all lacked the type of coercive threats that Kratz claims must be present outside of the employment context. These courts found the sexual conduct in question still constituted sexual harassment in violation of the Equal Protection Clause. Of course, absent more obvious forms of sexual harassment, an equal protection claim may be more difficult to prove. An equal protection claim based on sexual harassment generally follows the contours of Title VII allegation of sexual harassment. Importantly, not all conduct that can be considered sexual harassment in the employment context is actionable. In order to demonstrate a violation of Title VII, the employee must show the discrimination is of such severity or pervasiveness as to create a hostile or abusive work environment. Quoting the EEOC guidelines on workplace sexual harassment, the court in Vincent explained that unwelcome sexual advances, requests for sexual favours and other verbal or physical conduct of a sexual nature constitutes prohibited sexual harassment, whether or not it is directly linked to the grant or denial of an economic quid pro quo, where such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile or offensive working environment. Whether the harassment rises to this level turns on a constellation of factors that include the frequency of the discriminatory conduct, its severity, whether it is physically threatening or humiliating, or a mere offensive utterance, and whether it unreasonably interferes with an employee's work performance. Ultimately, the test of whether sexual harassment creates a hostile work environment is both subjective and objective. The plaintiff must subjectively believe the harassment was sufficiently severe or pervasive to have altered the working environment, and the harassment must also be sufficiently severe or pervasive from the standpoint of a reasonable person to create a hostile work environment. While the subjective element is often easily established for summary judgment purposes, determining whether the evidence is sufficient to support a finding that the objective element exists often proves more difficult. This is because the line separating behaviour that is actionable from what is not is less than clear. On one side lies sexual assaults, other physical contact, whether amorous or hostile, for which there is no consent express or implied, uninvited sexual solicitations, intimidating words or acts, obscene language or gestures, pornographic pictures. On the other side lies the occasional vulgar banter tinged with sexual innuendo, of course, or boorish workers. I think we'll leave it there and carry on with the in the next video. As I say, it just beggars belief, doesn't it, that in a case which, yes, it's important to Stephanie, and it was important from a sort of publicity point of view, but it's how can I say this? We've got Stephen Avery sitting in prison, clearly wrongfully convicted, and Judge Angela Kasukovic couldn't care less. She just doesn't want anything to do with looking at the legal aspects of this, and yet when it comes to William Griesbach looking at Ken Kratz's sexting career, at least we find here that there is a judge who is taking the time to look at this case thoroughly and to do a proper report on it. And as I say, the contrast between the two just beggars belief for me. Anyway, we'll catch you again soon. Hopefully my throat will have improved. So anyway, bye for now.